Hello, compliance managers and legal eagles. C-Quel invites you to taste a healthy serving of the 4 new labor codes. Don't miss this unique compliance bowl that gives your company's compliance a healthy burst. But first, let's gather the basic ingredients of this compliance bowl. So, 29 existing labor laws have been tossed into 4 labor codes. How does your compliance calendar change? How do your labor costs change? How do your HR policies change? How do your vendor agreements change? How does your compensation structure change? All this and more comes up in a healthy mix of facts and critical analysis that we are sure will do wonders for your compliance health. Did this happen overnight? No. Since 2014, labor law reforms have been coming fast and furious, and these reforms have rested on 3 planks: amendments to existing labor laws, digital delivery of labor services or e-governance, and digitization of labor records. Between 2014 and 2019, some of the important labor amendments for establishment and factory compliance were Bonus Amendment 2015, Maternity Benefit Amendment 2017, Fixed Term Employment introduced in 2018, Gratuity Benefit increased to 20 lakh rupees, Online PF ESI registration and state labor licensing and renewals, growing importance of POSH compliance. All these amendments were meant to infuse ease of doing business and anti-corruption in the Indian labor law regime. The Code on Wages was notified with effect from 8th August 2020, and the 3 other codes were notified on 29th September 2020, namely the Social Security Code, the Occupational Safety and Health Code, and the Industrial Relations Code. Please refer to the description box below for details on which laws have been subsumed under which code. But hold on! This large serving of 4 labor codes in one go should not give you indigestion. It's important for you to know right at the beginning that though the said 29 legislations stand repealed, the labor codes themselves are yet to be notified and implemented. The Government of India is yet to announce the dates of commencement for each code, since separate rules need to be framed under them. Hence, this discussion is primarily for informative purposes and to prepare for what's coming. So what are the main ingredients across all the 4 codes? Let's peek into the compliance bowl once again. 1 registration, 1 license and 1 return for all codes. 1 definition of wage across all codes and benefit payments. Wage not to be less than 50% of monthly fixed pay or gross notional pay. Separate definition of worker and employee. Changes in EPF contribution rate. Social Security net of EPFO and ESIC to include gig workers, platform workers and unorganized sector workers. Focus on interstate migrant workers and sales promotion employees with major impact on principal employers' contractor compliance duties. State-level PF proposed for unorganized sector workers, thus increasing employers' responsibility for contractor compliance. Contractor to include subcontractor as well. So what's going to be the overall impact on contractor compliance, including the quarterly income tax 26Q contractor TDS check? Clearly exponential, with principal employers' duties being enhanced to extend social security coverage to the unorganized sector as well, and reporting compliance to both the center and states. Fixed-term employee to get same service condition, gratuity, leave and social security as that of regular employee. Pay parity to women workers as compared to their male counterparts. Appointment letters for all types of employment, whether permanent, fixed-term, temporary or contractual, now made compulsory, otherwise to be treated as contract labor. Contract labor not to include permanent workers of contractors who enjoy social security benefits. National Occupational Safety and Health Board to be set up for providing international level safety environment. 50% of the penalty in case of accident to go to the workers along with other dues. Compounding of offence in place of outright prosecution of employer. The IR Code and the Social Security Code state that the offences punishable with imprisonment up to 1 year or with fine will be compoundable. In the Code on Occupational Safety, 50% may be compounded where a penalty is levied, for example, for non-maintenance of registers, and 75% for the offences, for example, for falsification of records. However, while serving up a healthy option for compounding of offences, there are going to be tough penalties for basic non-compliances such as non-maintenance of correct or proper registers. So frankly, there will be no option to manage compliance by managing inspectors, since compliances will be e-inspected, non-negotiable. Let us look at the penalty platter. Code on wages, imprisonment up to 3 months and fine up to 1 lakh. Code on industrial relations, imprisonment up to 6 months and fine up to 20 lakh. Code on occupational safety, imprisonment up to 3 years and fine up to 20 lakhs. Code on social security, imprisonment up to 2 years and fine up to 2 lakhs. However, we find certain ingredients in the 4 codes which are hard to digest, and trust these will be fixed in the upcoming rules. The Code on Industrial Relations fixes the limitation for qualifying period as 1 year to be eligible for gratuity payment. The Code on Social Security and Code on Wages is silent on this issue. Bonus eligibility was earlier capped to employees earning 21,000 per month. The Code on Wages does not mention such capping, leaving room for confusion. Labour offices across the country are making the certification of standing orders mandatory while applying for or renewing contract labour licenses and registrations. However, the IR Code makes it mandatory to establishments having more than 300 workers to get their standing orders certified. The guiding provisions for termination of employment are unclear, since the chapter dealing with the topic under the Industrial Disputes Act is only applicable to factories, mines and plantations and not to non-factory establishments. Confusion persists about the definition of a wage threshold to define the term workers, where the Code on Wages caps the monthly wage at Rs 15,000 while the Code on Occupational Safety caps it at Rs 18,000. Similar wage threshold confusion persists for sales promotion employees as well. Now that we know the main ingredients, how are compliance managers going to digest this? Let's look at the impact on the compliance bowl. Exponential rise in compliance obligations, principal employer liability to increase manifold. Clearly, these 4 codes are set to change HR policies and payroll processing structures in a major way. Employee benefits manual will have to be rewritten. Instead of 13% PF contribution on basic and DA by employer, we are looking at 10% PF contribution and unified PF ESI payments. Contractors and subcontractors including gig workers, migrant workers, PF ESI responsibility becomes an additional obligation for the employer. This audiovisual presentation is meant to give you the outcome of the compliance bowl made on the kiln of EODB and anti-corruption. We are listing out the detailed recipe and ingredients below in the description box. The Code on Wages 2019 highlights establishment to include all commercial establishments, separate definition of worker and employee, nomination for unpaid salary dues to be available, code to be applicable to all workers unlike the Payment of Wages Act which covered employees earning below 24,000 per month. Transgenders to be protected from discrimination in remuneration for similar work. Contract labour not to include a worker who is regularly employed by the contractor for any activity of his establishment where such employment is governed by mutually agreed terms and who gets periodical increments, social security and other benefits. Employer to pay minimum bonus at 8.33% irrespective of allocable surplus. An employee can receive a maximum bonus of 20% of his annual wages. Wages defined in 3 parts: inclusions, specified exclusions and conditions governing exclusions. Amount of exclusions not to exceed 50% of total salary, else to be deemed as wage. Time limit for payment of monthly wages is before the expiry of the 7th day. For retrenched, dismissed, closure cases within 2 days of such event. Overtime payable at twice the normal rate of wages. The Code on Social Security 2020 highlights important definitions in the code include fixed-term employment, gig worker, home-based worker, interstate migrant worker, platform work. EPFO's coverage would be applicable on all establishments having 20 workers. Earlier, it was applicable only on establishments included in the schedule. Option to join EPFO is also being given to establishments having less than 20 workers. Schemes would be formulated for bringing workers coming under the category of self-employed or falling under any other category under the aegis of EPFO. In the EPF scheme, the employer and employee will make matching contributions of 10% of the employee's wages, which may be increased to 12% by notification. For the purposes of Chapter 3 EPF, the age of superannuation shall be 58 years, extending the reach of ESIC to maximum possible workers. The facility of ESIC would now be provided in all 740 districts. At present, this facility is being given in 566 districts only. The Code on Industrial Relations 2020 highlights, the definition of worker will be based on the basis of wages being drawn by him. Workers and employees with salary up to 18,000 will fall under the category of worker. Establishment with less than 300 workmen can lay off, retrench, close without government approval. Earlier, this limit was 100 employees. The provisions of standing orders will be applicable on industrial establishments having at least 300 workers. A new feature of recognition of negotiating union has been introduced. Employee can raise an industrial dispute with the employer within the time limit of only 2 years instead of 3 years. Trade unions have to give notice of 14 days before going on strike. The Code on Occupational Safety, Health and Working Conditions 2020 highlights, the 2020 code increases the threshold for being considered a factory to 20 workers for premises where the manufacturing process is carried out using power, and 40 workers for premises where it is carried out without using power. The code includes all establishments where any hazardous activity is carried out regardless of the number of workers. Daily work hour limits fixed at 8 hours per day. New definition of employer and industrial premises. Definition of interstate migrant worker modified and ceiling limit of Rs 18,000 introduced. Prohibits contract labor in core activities except where the normal functioning of the establishment is such that the activity is ordinarily done through contractors. The activities are such that they do not require full-time workers for the major portion of the day, or there is a sudden increase in the volume of work in the core activity which needs to be completed in a specified time. Employment of women. Women will be entitled to be employed in all establishments for all types of work. In case they are required to work in hazardous or dangerous operations, the government may require the employer to provide adequate safeguards prior to their employment. Hey, we hope that wasn't too hard to digest. Visit us at www.C-Quel.com for a full download. Ask C-Quel at info@C-Quel.com in case you require more advice. Stay compliant, stay healthy.